And welcome back. Now, the Constitutional Court will later this morning hear a contempt of court application brought by the Zondo Commission of Inquiry into allegations of state capture against former President Jacob Zuma. The Zondo Commission wants the former president to be imprisoned for 2 years if the Constitutional Court finds him guilty of contempt of court. Now, the application stems from Zuma's defiance of the ConCourt ruling instructing the former president to give evidence before the commission. And Zuma, however, alleges that the commission and the Constitutional Court are victimizing him through exceptional and harsh treatment, and that both institutions are politicizing the law to his detriment. The Commission, however, says that Zuma's public attacks on the inquiry and the judicial institution are unjustified, untruthful and malicious. Professor Pierre de Vos, a constitutional law expert, joins us now to talk more about this. Professor de Vos, always good to see you. Thanks so much for speaking to us.
Good morning.
So let's just start by taking a look at how all of this has unfolded, and starting with the question as to whether the former president's conduct and what is playing out at the moment in the Constitutional Court poses any sort of threat to South Africa's rule of law and, of course, the legitimacy and effectiveness of, one, the judicial system, and two, the Commission of Inquiry into allegations of state capture.
Well, clearly the aim is to discredit the judicial system and the Commission of Inquiry, and ultimately the report that the Commission will produce. Because obviously if there's legal proceedings and you just ignore the law, if there's court orders and you just ignore the court orders, it might invite other people who are have maybe not as high a status as you in society to do the same. As we have seen, one person has already declined to testify before the Zondo Commission, citing the former president's action. So there's clearly a problem. How the Constitutional Court is going to deal with it, that is, of course, what we are now waiting to see.
Now, the former president, Professor de Vos, did publicly state that he will not cooperate, that he will not give evidence at the Zondo Commission. So let's talk about that in terms of what that does to undermine not just the matters that you've just outlined, but undermining the public trust in the commission and in the judicial system.
Well, the whole judicial system, in a way, works on legitimacy and it works on trust. Remember, there's a famous quote by the former Chief Justice Mohammed, who pointed out that courts do not have the power to impose taxes, they don't have a police force, they don't have an army. They are obeyed because we accept that the system is what it is. Even if we don't agree with a specific judgment, we can appeal it, but people are supposed to respect the courts and the judicial system. What's happening here is that the former president has said, because I don't agree with the rulings you made against me, because it's not in my interest, I don't want to testify, because if I testify, I don't know what, I might incriminate myself and I might be sent to jail. If you do that, you are sending a signal that the whole system, if you're powerful enough, if you have enough money, you can just ignore all the rules, unlike everybody else. So you're asking to be treated specially and not equally with everybody else, but in a better way. And I think that is really what has happened here, as the Constitutional Court pointed out when they made the order ordering the president to testify.
So the former president feels he's not getting fair treatment. He feels that the commission is biased towards him in some way. And in Zondo's, in the commission's application, it states that one of the forms of contempt that they are citing here is the crime of scandalizing the court. Tell us what that means and if that is actually a punishable offense in Zuma's case.
Yes, so in this case, it's actually, in the end, they didn't ask the court to make a finding on scandalizing the court. They just said it should be an aggravating circumstance when deciding what punishment to impose. But unlike when the contempt of court before the court now is refusing to obey a valid court order. Scandalizing the court is when you make all kinds of unsubstantiated allegations against a specific judge or a specific court. You claim that the judges are bribed. There's no evidence for that. You claim that the judges are all out to get you. There's no evidence for that. So you basically, you're attacking in a completely factually unsubstantiated way, specific judge or the judiciary as a whole, to try and defend yourself politically because you're legally on the wrong side of the tracks. But as I've said, they raise it in their papers, but they argue in the end that they're not going to pursue it because there would need to be a far more elaborate process for that to be ventilated if the court was going to make a finding on that particular issue.
And let's just deliberate a little bit about the former president's assertion that he feels that this commission is biased against him. It was, of course, ventilated, it was dealt with, but the former president also felt that the person whom he was actually making this charge against in the form of the Deputy Chief Justice, who then presided over that very same issue, was seen by him as, not having a fair day in terms of that particular question. What's your take on that?
Well, my take is not really relevant. What the law says is that if you're a presiding officer, judge in a court, and somebody says, well, we want you to recuse yourself, the only person who can make that decision on recusal is the very judge whose recusal is being sought. So this is different from other parts of our law. It's not only permitted, it is required for that judge to make the decision, because the argument is that judges has to manage their own integrity and the integrity of the judicial system. So you make the decision. Nobody else can make it. So the argument that the former president makes that somebody else should have made the decision is a legal nonsense. It's not how it works. So in our law, a recusal is actually very difficult to secure. The Constitutional Court has said in the famous Sarfu case, where Mr. Louis Late asked about 5 judges of the Constitutional Court to recuse themselves, that the starting point is, as a judge, you don't recuse yourself because the assumption is that you can act. Even if you know some of the parties, you can act impartially. It's only when a reasonable person, with all the evidence before him or her, will have a real fear that the judge will be biased, that judge has to recuse him or herself. In that Sarfu case, the court said, well, the fact that the Chief Justice was friends with President Mandela, and President Mandela was one of the parties in the case, is not going to meet the requirements for recusal. So it's not easy to convince anybody of recusal because it is
And precisely for that reason, did the former president have any further recourse in that matter that he could possibly have pursued?
Yes, so if you ask for a recusal and this is declined and it's from a lower structure, you can, of course, appeal or have the decision, in this case, because it's not a lower court, it's a commission, you can have the decision reviewed in a court of law. Former president has said that he is going to lodge such a review in the High Court. I don't know where we are with that. But he then mistakenly said because he lodged this review application in another court, he doesn't have to obey the Constitutional Court order, which legally, of course, also is a nonsense. You cannot ignore one court order because you are appealing another matter in another court.
So coming to that, what are the chances, Professor de Vos, of former President Jacob Zuma actually being found guilty of contempt of court and actually spending any time in prison?
Yes, so the first part of the question, the law is quite clear. In this kind of contempt, it's a civil contempt where you don't obey a court order. The party coming to the court, the commission, they have to show that there was a court order, that it was disobeyed. then the onus actually shifts to former President Zuma. He has to show that he had not done so deliberately, willfully, with intention, but he's not before the court. He's, in a way, he's decided that he's not going to participate. So that means, I think, that it is pretty certain that he will be found in contempt of court, given also that he had actually made statements in which he claimed that he wants to be in contempt of court. What the sentence will be, I think, is the real issue. Will it be? Will there be an attempt to get him to change and to do to be interviewed and to answer questions, in which case court might impose a suspended sentence saying that you will go to prison unless in the next 3 weeks you go and testify before the State Capture Commission. That's one option. Another option is just incarceration. That is what the Commission is arguing for in their papers. Or you can have a fine and additional suspended prison sentence. So I think maybe some of the arguments today will be about what the best and most appropriate punishment would be in this particular case.
So also please explain to us why the Minister of Police and the National Commissioner of the South African Police Service are the second and third respondents respectively, following Zuma as the first respondent.
The reason for this is, as I said in the beginning of the interview, that the courts do not enforce their own orders. The orders of courts, whether it's a guilty finding in a criminal case or whatever, is enforced by law enforcement, by the South African Police Service. So I think they are cited because the Commission wants to make certain that if there is a finding of guilt, and if the former president is then sentenced to a mandatory prison sentence, that order will actually be executed, because that will be far more dramatically wrong and dangerous for our system would be if there is an order for the president to be imprisoned, former president to be imprisoned, and the police do not actually enforce that order, because then the whole system falls apart. It will be a complete disaster. So I think that might be the reason.
Well, we'll keep our eyes trained on the proceedings later today in that court. But thank you so much, Professor Pierre de Vos, expert on constitutional law, for talking to us about the Zondo Commission's contempt of court application against former President Jacob Zuma, which will be heard in the Constitutional Court later this morning. Let's take a quick break before our 7 o'clock news bulletin.